Welcome, everybody, to another edition of CRA Sessions, CRA's podcast. I'm Dave Duski. I'm a principal at CRA in its intellectual property practice based in Chicago. I'm a CPA by trade, and most of my work focuses on intellectual property valuation, damages assessment, and expert testimony. And with me today is Brian Nolan, a partner at Mayer Brown in its intellectual property practice based out of New York. Brian, welcome. Thanks for being here.
Well, David, thank you for having me up to Boston on this lovely summer day.
It is a nice day. Maybe you can just spend just a quick minute or so giving a little bit about or background about yourself to the listeners today.
Sure. So I'm a partner in Mayer Brown's IP group in New York City. My practice focuses on all ranges of IP, including adversarial proceedings in district courts and appellate courts and at the patent office. Also, all types of patents and trade secrets, coupled with transactional matters. And I also sit on Mayer Brown's AI steering committee.
I'm excited to have you today because the topic of conversation is going to be the intersection of AI with trade secrets. And we've been hearing a lot about how AI is playing a role as an inventor and a creator of intellectual property. And companies appear to be turning towards trade secrets as a means to protect that intellectual property that results from, at least in part, the assistance of AI. So I guess my question to you is that what you're seeing in your practice? And if so, why do you think companies are really leaning on trade secrets now to protect their AI inventions?
Well, we've certainly seen an uptick in trade secrets and particularly a focus on using trade secrets in the artificial intelligence space. And I think there's a few reasons for that. First of all, there's no question that what comes out of AI or even the models and the components that you build for AI can be protected by trade secrets because trade secrets protect any information that has value from not being readily well known or readily ascertainable. And you can describe many aspects of AI, be its models, the structure of it, the data that you use, compositions of data to protect from AI, from trade secrets. There are also some concerns we see in the patent space because with many computer-based programs, there's always a question of patent-eligible subject matter. There was a recent case out of the Federal Circuit which held just using new data with a standard machine learning methodology is not going to be patent-eligible subject matter. There's also the concept of, we know in the United States that you have to have significant human contribution to be named as an inventor, and inventorship dictates ownership. And the question becomes in that analysis, if AI is generating the intellectual property, can you point to that significant human inventorship? So all of those issues go away kind of from a trade secret perspective because ownership is just dictated by possession. Do you have the legal right to have it? You don't have it doesn't matter that if it all comes out of the artificial intelligence, as long as you take the steps to protect, reasonable steps to protect it. And we're also seeing, I think, a broader understanding of improper means or what may be considered improper means from a misappropriator or an alleged misappropriator, because unlike patents, you'd have to have the improper means of acquiring it to make a trade secret allegation, whereas patents, it can just be independent development can still run afoul of a patent.
Right, and you theoretically have indefinite protection, right, unlike patents, so long as you keep the trade secret a trade secret in reasonable measures to protect it. So unlike patents where you may have protection for 20 or so years, trade secrets offer presumably the added benefit of kind of that, indefinite period of protection.
I think it adds benefit on the back end, like you're saying, because it can go on as long as it doesn't become publicly known. And also on the front end, because with patents, you have to wait for a government agency to grant you that patent. And where trade secrets, it becomes a intellectual property as soon as you have identified it, you've taken the reasonable steps to protect it. And in considering the fast-moving pace of artificial intelligence, some feel like the added time of acquiring that patent, by the time you get it, will the technology be obsolete? Will your claims be defined in a way that it's relevant to what people are doing once the patent issues?
Good point. And we're about 9 years in now on the passage of the DTSA, the Defend Trade Secrets Act. And more or less over the last few years, we're seeing about 1,000 or more trade secret cases filed in federal courts across the country. I mean, what impact do you think the DTSA has had in making trade secret protection a little more attractive to companies?
I think having a federal statute that gives you jurisdiction in district courts is very appealing to many attorneys and many companies. There's consistency across what the causes of action will look like. Mm-hmm. It doesn't supplement your state cause of action, doesn't replace your state cause of action. It does supplement it. So you can have a DTSA cause of action and still have your state cause of action if you think that is appropriate. With respect to a comparison to DTSA in some states, I think people look at the DTSA as having broader protection of trade secrets, or a broader definition of what can be a trade secret, more flexibility with damages awards and injunctive relief, as well as just a feeling that you have a comfort level to know I can apply this irrespective of the jurisdiction that I'm in.
So what would be a reason you could think of why a company would still decide to litigate under a state cause of action, like under each state's Uniform Trade Secret Act statute? Like, would there be any perceived benefit in doing so as opposed to filing under the DTSA?
Well, I think it would depend on the state cause of action you're looking at. And oftentimes, some companies just decide they want to be in state court because they like that jury pool better, they like that location better. There may be some benefit to them being in that state court. I think that's lesser of a consideration, but it certainly happens, and we've seen big damages awards coming out of state court actions where it wasn't focused on the DTSA. But I think in general, you would most often include a DTSA. Again, that's if you want to be in federal court. You can't bring a DTSA action in a state court. So if you wanted to be in state court, you're not going to choose that cause of action.
Right. And you brought up something interesting, some large damages awards that have been in the news over the last several years in trade secret cases, both coming out of federal courts and also state courts. And I oftentimes think, like, why that is. Why are we seeing such large damages awards, from a jury verdict? Now, let's set aside what may get reduced on appeal or post-trial from the trial judge. And, as I think about this, a couple reasons come to mind as what may be given rise to some of these large awards. One is the availability of unjust enrichment under the DTSA and most states' Uniform Trade Secret Acts. Of course, unjust enrichment, you're trying to, as the trade secret owner, disgorge the ill-gotten gains of the misappropriator. And that's not a remedy, as I understand it, that's available under Section 284 when we're talking about patent damages. And I feel like there's so many different ways now you could measure a accused misappropriator's ill-gotten gains that kind of give rise to large damages amounts. So it's not always just limited to the misappropriator's profits. I think that's one measure of unjust enrichment, but oftentimes in trade secret cases, you're faced with companies that are startup companies or new ventures that are just getting off the ground and may not have earned a lot of sales and profits yet to disgorge. But that by means, based on my experience, is not the only way you can measure unjust enrichment. Another common way of looking at it, and we'll talk in depth about this, is avoided costs. What did the misappropriator avoid in terms of development costs and time to gain the trade secrets by unlawful means? Because that is a perceived benefit to the misappropriator that in most jurisdictions is eligible for disgorgement. We've also seen, I think, in cases where the business unit or the entity that has alleged to misappropriate the trade secret may have been sold off as part of a larger transaction or been acquired by a larger company, and there's been some attempt to tie the value of that acquisition to the trade secrets. And I think that if a trade secret owner could do so, and there's sufficient evidence to rely on to do so, that could potentially lead to large damages awards as well. Likely, or similarly, I should say, when you're dealing with startup companies too, they're oftentimes looking for funding. And for example, if you have a company that's pitching to investors some new technology that perhaps relates or is the trade secrets, and again, you could tie the funding to the alleged misappropriation, that could be another potential measure of ill-gotten gains. Now, of course, it depends on the specific facts and circumstances of every case, but I think that's what we've been seeing. So is that kind of your view as well?
I agree with that entire analysis that you laid out there. And I said, going back to the original question is, why are we seeing increased damages or high damages, particularly at the trial level? And I think it comes down to is people like you, Dave, you're really good at explaining this to juries. And it makes us as trial lawyers easy to work with, good experts that go through and do that analysis early on that you just went through. And you say, with that flexibility that we see in trade secrets, where you can get the trade secret owner's lost profits, which is one measure of damages. And as long as you can show that you're not double dipping, that there's not an overlap, you can also go and look at what is the benefit. And as you described, the kind of the unjust enrichment to the person that has misappropriated that. And when you work with somebody like yourself or other experts, that you can walk through that and said, should we do this as an analysis of what costs they avoided? And oftentimes a proxy for that may be what the trade secret owner spent on it. Or should we do it from the perspective of what value did they get? Maybe an increased valuation for their company at some time when they had some investment, or an increased premium when the companies was sold. So I think everything that you said there and how you stepwise and walked through all of those potentials is precisely why it's important to consider this early on. We always want to build the factual liability story and say, these are my trade secrets because the court's going to make us define them with reasonable particularity at some point. And this is how they've been misappropriated. But as you're doing that, concurrently with doing that, you want to be analyzing all the issues that you just went through. And then you want to be careful, because if you have, it's usually not one trade secret. You may have a whole host of trade secrets. And then you might have to look at an issue as, well, what happens if you only prove misappropriation of some and not all?
Right.
And then how are your damages impacted? So working early on with somebody like yourself is vital to maximizing your potential reward at the end of the litigation.
No, I agree completely. And sometimes one of the hardest parts of a damages analysis in a trade secret case is that kind of apportionment analysis and scenario planning, because there's been cases recently where hundreds of trade secrets have been asserted. And what do you do if only some of those trade secrets are found, in fact, to be one, trade secrets, and two, misappropriated? And there's some courts that have been very vocal that if you present a singular damages number to the jury and the jury comes back with something less than all of the trade secrets to be found to be trade secrets and misappropriated, you have a problem, or could have a problem. There's certain cases where the trade secret owner has argued that, well, if, the trade secrets are kind of like locks on a door, and if you, as long as you misappropriate one, you wouldn't have gotten the benefit that you did. Therefore, a singular damages award would be appropriate. So that is often something that you need to focus on early on in the discovery phase. The other thing that I've noticed too, I think, with these large damages awards is extraterritorial issues, as we saw in like Motorola Hytera. I mean, do you think that is leading towards some larger awards, that potential availability of foreign damages?
Well, I think the extraterritoriality of the DTSA, that you can look at actions outside the United States, is something that is very favorable to trade secret owners and why they like the statute. And as long as you can show that there were significant acts in the United States that led to that, I think that is another reason why you're seeing both the use of the DTSA and increased damages awards. And then one other thing that I was reminded of when we were talking about the requirement to work early with an expert and somebody like Dave to break down the valuation of the individual trade secret and tie it into your damages award. Another thing that you want to be careful with, and I think you could probably highlight this for us, is oftentimes, as you noted, the company that may have misappropriated the trade secret may be a newer competitor, maybe a smaller competitor. So the equitable relief, the injunctive relief may be more important. And we just have to be careful with when we build an unjust enrichment theory, and if we look at, say, avoided cost, and we say build that theory in a way where the damages are looking at prospective value to the company that's been found to misappropriate, how do we balance that with the potential for a court to say, well, I'm not going to give you the prospective injunctive relief because you're getting a prospective monetary relief. So when you approach a case, how do you balance those two issues when you build your damages theory? Do you keep the injunctive aspect in mind when you're looking at it?
It depends. Ultimately, that is kind of a legal question of whether or not injunctive relief and equitable relief, could they coexist? And I think it depends on the facts and circumstances of any given case. What we saw most recently in the Insulet EOFlow case is the trial judge post-trial reduced the compensatory damages award because, among other things, the court found that there was an element of double counting in there with specifically injunctive relief being sought because my recollection is the unjust enrichment was based in part on projections of future sales and profits of the defendant in that case, and the court found that that could be construed as double counting with injunctive relief because the trade secret owner is seeking to enjoin the defendant from being able to use the trade secrets going forward. But also now you have a situation in which the damages that were awarded already factored in future use of the trade secret there. So, it's a fine balance. And I think in the Insulet case, from what I've read, is it seemed like Insulet perceived the injunctive relief to be a little more important to them than the large damages award, because I think according to the briefs and the order that I read, EOFlow, who was the defendant in that case, only had something like $25 million in assets, and the compensatory damages award was, several $100 million. So they could have been thinking to themselves, well, we might not be able to collect on that award. So what is more valuable to us? And that is, prohibiting EOFlow from being able to use our trade secrets going forward. That is more important to us from a competitive advantage than the monetary relief that the jury awarded.
I do agree with you that it's all fact specific, but one thing I will say that makes my life easier when I'm building a trade secret case is working early on with somebody like yourself, where we want to say, if we think that we're going to be able to meet the 4-factor test for the injunctive relief and that equitable relief is something that's going to be important, and we want a broad scope of that, to work early on with you and colleagues like yourself to base as much of the damage as we can in activities that have already occurred or facts that we're already looking at. So it becomes easy for us to explain to the judge, here's why there's not double counting. Here's why there's not double dipping, because this is the injury that we're being compensated for, and that injury's in the past. And that's where the financial aspect, that's where the legal remedy is coming in damages. And here's the injury that we're seeking to prevent in the future. And that's where the equitable injunctive remedy comes from. And if we can work with you and others to delineate that early on, it makes it much easier in the post-trial briefings and the injunctive briefings to lay that divide out for them. Yeah,
to me, it's very akin in patent cases to where a jury comes back with a lump sum damages award, but then the trade or the patent owner also seeking an injunction, and then most courts see a conflict there because ordinarily a fully paid up lump sum license is in conflict with an injunction where you're saying, okay, well, I'm going to pay you all this money up front for, a hypothetical, license for the life of the patent, but now I'm going to also try to enjoin you from being able to use it post-trial. So that's, kind of an analogy of what we're seeing in trade secret cases. But, the final point I want to get to that has come up in a lot of cases is, can recovery of avoided costs, specifically, and injunctive relief coexist? And, just as background, avoided costs is one potential measure of unjust enrichment. In other words, what is the time and the money that the misappropriator saved by misappropriating the trade secret? And can an award of that amount exist and coexist when there may be a permanent injunction? And it's interesting because there's a couple cases out there that have taken a different view on this. Specifically the Sintel-Trizetto case went up to the Second Circuit, and the Second Circuit said in that particular case, it didn't believe that avoided costs were appropriate. Now, it didn't say that as a matter of law, as I understand it, but it said in that particular case it wasn't appropriate. And then you have insolent EOFlow, where the district court applied these three factors from the Sintel case and said, okay, well, if you apply those factors the court laid out in this case, we believe injunctive relief and recovery of avoided costs is appropriate. So it kind of leaves us with some unsettled case law, at least in my view, because it's an interesting topic.
Well, I think it provides direction, though. Both of those cases provide direction. One thing, the first case you discussed, Ed, coming out of New York, that's a good example where avoided costs are not available under the New York Trade Secret Act, but you can use the DTSA to get that. And I think this dovetails nicely with the last discussion that we had, is in the sense that if you can show the benefits that have been received by the alleged or misappropriator, now, if you're at liability, they've been found to be a misappropriator. If you can show the benefits have already been received for the avoided cost, maybe it allowed them to explore a new business unit, maybe it allowed them to take some steps and receive some sort of benefit. Again, if that harm has already occurred and the benefit has already been obtained, then you can compensate that through damages. It's when the avoided cost scenario becomes, we spent all this money, say, on a product that we're just about to launch, and then they prevent you from launching the product. If all of that tie into the avoided cost is the prospective sale of that product, then I think courts become a little concerned. Is there going to be a double dip between the equitable injunctive relief and the legal relief? But again, this is all why it's important, I think, to consider this early and consider it from a financial perspective, because as lawyers, we can theoretically talk about it, but somebody like yourself has to then put the numbers down on and then say, I'm getting this number from here, and this number ties into this benefit, and that benefit has been received already, or something in that sense. And then therefore, once we have those delineations of why the avoided cost, the benefit has already been received, I think we're in a better position to articulate why there may not be double recovery in that avoided cost circumstance when you're still asking for equitable or injunctive relief.
Right. Yeah. And those are some good arguments I think litigators like yourself are going to make. I mean, fortunately for us experts, I view that as kind of more of a legal issue where we could calculate the avoided costs. You could argue for injunctive relief, and then argue to the court why you don't believe that would be considered double counting. In fact, that they could, mutually exist. So it'll be interesting to see kind of how this progresses as time goes forward and more cases get litigated and these issues keep getting brought up. But, with that, Brian, I really want to thank you for being here and talking about this topic with us. I think it's top of mind. Companies are realizing the benefits of AI and what it could do in terms of intellectual property generation and creation, and trying to figure out how to best protect their inventions. So I think we're going to see a lot of these issues front and center coming forward. For those of you listening who would like to learn more, please visit CRA's website at www.crai.com. Thanks, Ryan, for being here.
Well, thank you for this very interesting discussion, and you have a good afternoon now.
You too. Take care.